Hello, everyone. Thank you so much for participating in my talk today on termination of employment contract, unfair dismissal, and constructive dismissal. And I believe that this topic here is very relevant to everyone over here being employee or perhaps potential employer in the future, we never know. But I hope that you will find this helpful. Bearing in mind that these are all the basic understandings of the topic here. So my sharing today will focus on four main areas: contract, its requirements, and also its benefits. Then I will venture into what amount to unfair dismissal. With that, I will also explain the concept of constructive dismissal, and finally on the remedies, on their respective remedies. First, termination. Now, in Malaysia, there are two main laws on, two main acts on employment. One being Employment Act 1955, and the other being the industrial. The difference between these two acts is the definition of, looking into the definition of employee. Under Employment Act 1955, employee is defined as those who earn the basic monthly salary of not exceed 2,000 ringgit. Act 1967, there is no such limitation. Basically, everything that does not fall within Employment Act 1955 will go to Industrial Relations Act. So now I'm looking into Employment Act 1955, covering employees who earn the monthly basic salary of not exceeding 2,000 ringgit. So the termination, in order to have have a lawful termination, to terminate a contract of service, bearing in mind that this is a two-way relationship. It can be the employer terminating the service of employee. It can also be the employee terminating his or her service with the employer. One of the requirements therein will be the notice requirement. So there must be a termination notice period in the employment contract. And with this notice period, of course, it has to be of the same length, same time frame for both employer and employee. Now, if there is an express stipulation, express provision in the employment contract on the termination notice period, the Employment Act will respect such period. They won't control as to there must be a certain length of this termination notice period. However, in the absence of such a provision, then the Employment Act does provide how long must the termination notice period be, depending on the length of employment of the employee. So under Section 12, Sub 2 of the Employment Act 1955, we can see that termination notice period shall not be less than 4 weeks if the employee here has been employed less than 2 years. It shall not be less than 6 weeks if the employee here has been employed 2 years or more, but less than 5 years. And it shall not be less than weeks if the employee here has been employed 5 years or more. Now, I have mentioned just now that the employment right, freedom of contract between parties, they won't bother much if there is an express provision in the employment contract on the termination notice period. How long is it or how short is it? However, there are some circumstances, there are some events that the law will will control the termination notice period. So these following events are where the law, the Employment Act will apply irregardless of any notice period in writing in the employment contract. One being if the employer here has ceased or intends to cease to carry out the business for the purposes of which the employee was employed in the first place, or that the place here at which the employee was contracted to work has ceased or intended to be ceased by the employer. Second, cease or diminished or expected to cease or diminished, or that the place at which the employee here was contracted to work have already ceased or diminished or expected to cease or diminished. Fourth being the employee here has refused to accept his transfer to any other place of employment, unless of course his contract or service has expressly stipulated him to accept the transfer. And then the last event is when there is a change in the ownership of the business for the purpose of which the employee here is employed in the first place, or any part of such business, regardless of whether the change occurs by virtue of a sale or other disposition or by operation of law. Now, notice requirement here can also be exempted as stipulated under Employment Act 1955. Here are some of the events when the notice requirement can be exempted. For one, if there is a waiver of right to notice by the other party. Let's say the employee here wants to terminate his contract of service. The employer here might waive off the right to this notice. Then the termination can be effective, can be with immediate effect, can apply with immediate effect. The other one being if there is payment in lieu of notice equivalent to the salary that the employee would have accrued during this term of notice or any unexpired term of such notice, or otherwise known as buyout, or if there is willful breach of employment contract. Let's say the employer here has failed to pay salary to the employee, or there is a misconduct committed by the employee. The employee has perhaps failed to do his work, then there is no need for termination notice. Sorry. Or if there is an immediate threat to the employee or his dependents of any danger to this person by violence or disease, such that the employee here has not undertaken to run in the first place. Now, the previous here that I've mentioned here are all under Employment Act 1955, governing the employees earning monthly salary not exceeding 2,000 ringgit. So what about employees here who have earned exceeding more than 2,000 ringgit? Under the Industrial Relations Act 1967, there is no express stipulations to as to what are the requirements to terminate a service of contract, a contract of service. So it will all boil down to the provisions of the employment contract in the event termination occurs. What are the requirements stipulated in the contract? Now we look into benefits, termination benefits under Employment Act 1955. Bearing in mind that this is for employees earning monthly basic salary of not exceeding 2,000 ringgit. So the conditions in order to claim such benefit, for one, is that the employee here has to be employed for a continuous period of not less than 12 months. So they have to be employed by the same employer more than 1 year. And this benefit here will not be applicable to the employee in the event that the employee here has attained the age of retirement, or that the employee here has committed any kind of misconduct, or the employee here has voluntarily terminated his own contract of service, unless this voluntary termination is due to the willful breach of the employer, or there is any immediate threat to him or his dependents by violence or disease that the employee here has not undertaken to run in the first place, or that the employee here has left before the termination notice has expired, without any prior consent of the employer or without having bought out his termination notice. So in the event the employee here has been employed more than 12 months continuously, is entitled to the termination benefit. How much benefit can he obtain? That also very much depends on the length of his employment. 10 days salary if he's employed less than 2 years, 15 days salary if he's employed 2 years or more but less than 5 years, and 20 days salary if he has been employed more than 5 years. Now, across the board to all employees, regardless the employee here has been has earned more or less than 2,000 ringgit per month, there is this employment insurance system benefits that covers monetary benefits as well as job search assistance. So this here covers quite a number of benefits. Monetary benefits, we have job search allowance. Yeah. Ini share screen.
Share dulu.
Bukan saya nak share ni.
Tak apa yang kat sana, kat Zoom.
Oh, really?
Share screen, pergi ke website.
Okay. Right. Okay. So for monetary benefits, there are 5 types. There are job search allowance, reduced income allowance, training fee, training allowance, and early employment allowance. For job search assistance, they provide 2 forms of assistance, one being re-employment placement program, as well as career counseling. So quite a number of benefits covered there. Then I need to stop sharing it. Okay, then the conditions. Conditions are first, the employee here can only work in only apply to employees working in private sector, not covering domestic workers, self-employed, civil servants, workers in local authorities and statutory bodies. Only cover those who are between the age of 18 to 60. However, if those aged 57 and above who have not contributed to the system before will be exempted. And then it will be capped at a monthly insured salary of 4,000 ringgit only. And for any person, any employee who wish to apply for such benefit under employment insurance system, EIS, they have to apply within 60 days after loss of employment. Now, we'll just stop share briefly to refer what does it mean to loss of employment. Now, loss of employment for the purpose of normal retrenchment and redundancy, voluntary or mutual separation scheme, closure of the company due to natural disaster, bankruptcy or closure of the company, constructive dismissal, and by extent it also refers to unfair dismissal, and then resignation due to sexual harassment or threats made in the workplace, resignation after being ordered to perform dangerous duties that are not within the job scope. And the following here will not be accepted as loss of employment, which are dismissal due to misconduct by the employee himself, voluntary resignation, retirement, or the expiry of a fixed term contract. All right. So after looking into the termination benefits, I will now look into the second part of my presentation, which will be unlawful dismissal. Unlawful dismissal, the tried law has always been dismissal, any kind of termination here must be supported with just cause or excuse. So any person here, any employee here who has been terminated of his or her services, he or she feels is without just cause or excuse, can file a written representation at the nearest office of the Director General of Industrial Relations, in short DGIR, within 60 days from So after receiving such a written representation between the employee, sorry, the typo, through conciliation process. So they will, the DGIR will call both parties to attend a meeting with the purpose of conciliation. However, if no conciliation is successful, then the DGIR will notify the Minister of Human Resources, who will then, if he thinks fit, refer this case to the industrial court. So when the matter here has come before the industrial court for its deliberation, the industrial court hears if whether there is any the complaint that has been made was in fact committed by the employee, be it misconduct, be it negligence, or any other complaint. They will first have to satisfy whether such a thing has happened. Second is whether the misconduct or any other complaint thereof constitute the just cause or excuse for the dismissal, whether the termination here is with just cause or excuse. So that is the tried law pursuant to the leading authority in the case of Wong Yuen Hop and Syarikat Honggang Insurance Berhad, another appeal decided by in the federal court. Burden of proof here for termination in unlawful dismissal case here will be placed on the employer in order to prove that the termination of the employee here has been done with just cause or excuse. Now, most likely than not, the employer here will say that the termination is done with just cause or excuse due to misconduct committed by the employee. So misconduct has been defined under in case law, in common law, meaning any conduct that is inconsistent with the faithful discharge of the duties or any breach of the express or implied duties of an employee towards his employer. So the court, in order to determine whether the dismissal or the termination here due to misconduct is reasonable, is with just cause or excuse, will only need to be satisfied that there is such a reasonable grounds for believing that the misconduct put against the employee here has been committed. So the test is not very much of proving whether the employee really has done the misconduct, but whether employer here has the reasonable grounds to believe in dismissing him. Now, this is a very much subjective view in the sense that there can be one employer who thinks that the reasonable conduct to take is to dismiss, while the other might take the view that to keep him on, so to speak, or maybe to just issue a fair warning, so be it. So both views, they are equally reasonable. However, if there is the view of dismissing him, which is also considered as reasonable, then the dismissal here will still be upheld as a fair dismissal. Now, another ground for termination would most likely also be unsatisfactory work performance. So unsatisfactory work performance here has been decided in this leading case, Ireka Construction Berhad and Chanti Anak Lelaki Subramaniam James, where the industrial court here has 3 elements in order to prove that the termination here is with just cause or excuse on the ground of unsatisfactory work performance committed by the employee. First, the claimant, being the employee here, has already been warned about his poor performance. Second, the employee here has been accorded with sufficient opportunity to improve. And lastly, notwithstanding anything said beforehand, the employee here has failed to improve his performance sufficiently. Now then, I venture into the distinction between probational, i.e. employee under probation, and also against confirmed or permanent employee. Now, there isn't much under the law here. They do not distinguish these two employees in a very substantive way, as they do share the same rights, i.e. the termination of the services will still need to be with just cause or excuse in order to be lawfully dismissed. So this is the case law supporting that view. However, being probationer, there is still this a certain distinction from being a confirmed or permanent employee is that during this probationary period, his character, suitability, and capacity put to test, and whether all these characters, suitability, all these elements prove him to be suitable or not for this position. So, and this here, the employer has the discretion to choose whether to terminate this probational during the probationary period or at the end of the probationary period. Nevertheless, it is still very much subject to termination with just cause or excuse. It has to be a bona fide exercise. Otherwise, the court will have the jurisdiction to interfere and also to decide that the termination is whether or not with just cause or excuse. And one thing that is distinguished from the permanent or confirmed employee here is that previously, for unsatisfactory work performance, one of the elements to prove is that the employee here has been warned about his poor performance. But for probational, there is this requirement, this warning requirement here is not required. Now, also there is this concept of domestic inquiry, whether or not it is required when it comes to terminating an employee's service. Many case law have in fact decided that no, even though there is a failure to hold any form of domestic inquiry, be it show cause letter or something along those lines, it will not be fatal. It will not be. It will not affect much the decision of the court in deciding whether or not the termination is with just cause or excuse. Now I'll look into the third part of my presentation, constructive dismissal. What exactly it is. Now, constructive dismissal is not provided anywhere in our written laws of Malaysia. It is in fact a common law principle. It basically is the right of an employee to terminate his contract of service and therefore to consider himself as discharged from further obligations if the employer here is guilty of such breach that affects the foundation of the contract, or if the employee here has shown the intention not to be bound by the employment contract any longer. So constructive dismissal, although not stipulated, not governed anywhere in our written laws, it still comes within the ambit of Section 20 of the Industrial Relations Act 1967. Therefore, any employee who finds himself to be in this situation, they can still make a written representation to the DGIR, who can then refer the case to the minister, who can then refer the case to the industrial court to be deliberated. There is a misguided concept when it comes to constructive dismissal that any form of unreasonable conduct of the employee here might consider that to be a constructive dismissal case. But that is in fact not true, because it will always boil down to the employee here has to be guilty of a breach which goes to the root of the contract, or that he has shown the intention that the employee here no longer wants to be bound by the contract. So this view has been supported by the leading authority in the Wong Chi Hong case again, that says that not necessarily that just because the employee here has been unreasonable means that there is a constructive dismissal case. For constructive dismissal case to apply, there are 4 requirements. First, there must be a breach of contract by the employer. Second, the breach must sufficiently be important enough to justify the employee resigning. Third, the employee here must leave in response to the breach and not for any other unconnected reason. And finally, the employee here must not occasion any undue delay in terminating the contract. Otherwise, he will be deemed to have waived the breach and agreed to vary the contract. Now, the last element here is very important, because any delay in termination of employment, i.e. leaving the employment here, will not constitute as a constructive dismissal. It will in fact be viewed as an affirmation of the so-called breach committed by the employer. So this view here is supported by this Court of Appeal case, Southern Investment Bank Berhad, or Southern Bank and another, and Yakfat and another, where it is stated that it is tried that for a claim of constructive dismissal, imperative for the employee here to take immediate steps to walk out of his employment within a reasonable time after the breach of contract claim, failing which the employer here would deem the employee to have waived the breach and agreed to vary the contract. So what are the normal grounds for constructive dismissal? Usually it will be non-payment of salary, there will be pay cut, demotion, or even transfer to a different position. Transfer of a different position will, I believe many will look into their employment contract and see there is a clause similar to this effect, that any transfer will not be a ground for a dismissal claim along those lines. So therefore, the court will look into the facts and circumstances of the case before deciding whether this particular transfer here amounts to constructive dismissal claim. So the court will look into whether there is anything contrary, anything written specifically in the terms of employment contract to restrict any form of transfer, whether the management, the company here has acted bona fide and in the interest of the business to transfer the employee, whether the company here has no indirect motive or any kind of bona fide, whether the transfer is not made for the purpose of harassing and victimizing the employee, and that the transfer here does not involve any change in the conditions of service. Now, I will look into the remedies of unlawful and constructive dismissal in the event, of course, the employee here has proven successfully that there is termination without just cause or excuse. Now, mainly there are 2 remedies available. For one is reinstatement, basically to reinstate back the position to his original workplace, original position. But most likely than not, reinstatement is not granted or is not suitable per se because of the irreversible damage that has already occurred between the employer and the employee. So in the interest of industrial harmony, reinstatement will likely not be granted. So as an alternative to reinstatement, courts has the discretion to order for compensation in lieu of reinstatement and also discretionarily back wages. Question of amount is very much at the discretion of the court, as stipulated under Section 30 of the Industrial Relations Act 1967, which provides that the court here has can act according to equity, good conscience, and substantial merits of the case without regard to technicalities and legal form. Notably, for back wages, it is somehow governed, it is somehow controlled under second schedule of the IRA 1967, that the court can only order for back wages for up to a maximum of 24 months based on the last drawn salary from the date of dismissal. So, but all in all, there is no fixed statutory formula provided anywhere in our written laws, very much subject to the facts and circumstances of the case at the discretion of the court. With that, finally, I conclude my presentation. Okay, Thank you so much for participating. I believe there is no question asked. Am I right? Wait, how to open? Yes, I believe there is no question asked. And with that, no question. No, go. Okay.